Blog Talk Radio.
He is the last of his kind. All that remains of a once powerful nation. Some think he is a myth. Some believe he is the chosen one, who will bring balance to a world at war. And some will stop at nothing to destroy him.
Welcome, Moors, to Moorish Talk Live 100. I'm your host, Tarhaka Bay, and tonight we will be dealing with setting up trust and using the private. We got one question we're going to deal with tonight, and we're going to look at that question from every conceivable angle. What are the benefits of setting up a trust? That's all we need to know. We're going to look at this thing. Excuse me. We're going to be coming to you straight out of our manual, out the trust manual, so you can get it straight. Make sure you got it right. And tonight we want to make sure that you got paper and pencil so you can write this stuff down. And after the broadcast, we will be posting this show on YouTube so that everybody will get a chance to learn this stuff. This is an educational segment tonight. We're going to go into some things. We're going to actually look at some trusts and how they are structured and the actual definition of what it's all about. We're going to get this stuff straight out of the manual tonight. Okay? We also have some plugs to run so that you can hear some live seminars and webinars so that you can hear this from the pros. And this is the kind of information that you want to listen to over and over and over again until you fully understand what you're about to be involved in when you're talking about being a secured party, and when you're talking about being a creditor in commerce and having the proper status in commerce. You want to learn this stuff, and the most important thing about all of it is knowing who you are and being able to be prepared to present proof of your identity, okay? And that's very, very important, knowing who you are. This is what it's all about, because we got a lot of people who they've tried a lot of different things. They have filed a UCC. They have done the addendums and all of this stuff, and then they are stuck. Well, what is it that I'm supposed to do next? What's next? So we want to try to make sure that you clearly understand the structure of how this thing goes. Before you do any UCC filings and any of that stuff, why don't you look at and establish and set up your proper trust? Now, there are many, many different types of trust. It depends on what you are planning on doing with your life. If you're if you don't plan on getting into business, if you don't plan on dealing with a corporation, if you don't plan on owning real estate investments or stock market investments, then there are certain types of trusts that you won't set up that'll benefit you. But tonight we're going to go over some of that stuff, and so that you can get a gist of what's going on and what you're faced with. Now I'm going to go to the commercials, and when we come back, then we're ready to go in. So y'all hold on.
Still, one of the biggest problems facing people in this country today is debt. The election of a new president doesn't mean your debt will go away. For student loan, child support, mortgage, foreclosure, credit card debt, etc., contact me, Tarhaka Bay, 904-303-9061 before 7 p.m. Eastern Standard Time, or visit newdebtelimination.com. You need to get out of debt now. Send for my free report by clicking on the Contact Us page at newdebtelimination.com. Fill it out, and I'll send my free report straight to your email address. Okay? That's www.newdebtelimination.com. Contact me directly, 904-303-9061, about solutions to the problems of debt. How to be a secured party. Freedom means everything, but what will you do when you get free? Do you just want to be left alone? Will you remain stagnant, or are you willing to delegate? Go to www.newdebtelimination.com. That's www.newdebtelimination.com. Or call me, Tarhaka Bay, 904-303-9061 before 7 p.m. Eastern Standard Time. That's 904-303-9061 before 7 p.m. Eastern Standard Time. Let's move into the realm of the secured party, and let's take advantage of what it means to be a creditor inside the United States of America. I have a question. What is your status in commerce? What is your diplomatic status? How do you use the common law? What is your legal and political status? What makes you a secured party? And once you are secure, what are you going to do with it? To get it all done right, go to www.newdebtelimination.com. That's www.newdebtelimination.com. Call me directly, Tarhaka, 904-303-9061 before 7 p.m. Eastern Standard Time. That's 904-303-9061 before 7 p.m. Eastern Standard Time. Let us show you how to be free.
And now, back to the show with Tarhaka and Moorish Talk Live 100.
Okay, we're back. Now, let me start off by saying that right now, ladies and gentlemen, down here in Florida where we are, we're under severe thunderstorm and tornado watch. We've had some places around here that's been totally devastated. I mean, just completely destroyed up in Georgia, and this thing is sweeping across the land. So, if we lose power tonight, you'll understand what happened, because this thing is, it's coming down. I mean, if we can make it for an hour, we'll be in the clear. So I'm going to go directly into this information to try to get as much done as we can. and got fingers crossed that we are going to make it through this thing, but this is devastating down here. We got golf ball size hail all over the place, tornadoes stretching straight across the land, totally annihilating houses and buildings, and I mean you can't even tell whether there was a house there or not. I mean, this thing is massive, man, and we are going through this right now. So just bear with me, and I want to let you know in the event that we lose power, what's going on. So you can look forward to us coming back at a later date and doing this thing again. We're going to look at directly at some of these trusts that we're going to be dealing with. And the first trust that I want to look at is one that a lot of people may not be familiar with. This is called an unincorporated organization business trust. It's commonly referred to as a UBOT. What is an unincorporated business trust, and what are its advantages? An organization created, a UBOT is an organization created and managed by trustees for the benefit and profit of the beneficiaries who hold or may acquire transferable trust certificates. Trust certificates provide individual holders evidence of interest in the trust estate, assets, and income. A powerful entity by which individuals may combine their resources to operate a business for profit without the inherent liabilities of a partnership or the double taxation of corporations. A UBOT can preserve privacy, protect assets against judgments and lawsuits. A UBOT is often called a common law trust, but this phrase is not descriptive of any of the peculiar characteristics of such an organization. The basics for the terminology common law trust is that they are created under the common law of contracts and does not depend upon any statute for its existence. See the United States Constitution, Article 1, Section 10, Clause 1. A UBOT brought into being by two basic documents, a declaration of trust and a trust indenture. These two documents make all the provisions of who is who and who is responsible for what relative to the trust activities. A UBOT, a great way to avoid tax liabilities of a business or trust transactions until money or assets are distributed to the beneficiaries. Since the trust indenture is a contract between the creator and the trustee, the indenture controls the activities, powers, and responsibility of those who administer the trust. No one has legal authority to change its provisions except those so authorized by the indenture. Okay. Now, I wanted to put that little bit of information out so we'll know the basic structure of what we're talking about. We're going to get back into some more of this here stuff. And I'll be coming back. We're going to look at some of the other trusts. We're going to actually look at how the trust is actually structured. We're going to look at it. How is it composed? How do you do this thing? I'm going to start off by saying that, first of all, when you're going to set up a trust, you want to make sure that the trustees are fully aware of what you are doing and what this thing is all about and where you are headed and the estate information. Because it is the trustees that are going to be orchestrating and administering the trust on behalf of the beneficiaries. Now, this is some very, very powerful stuff. So we have a package on my website called the Secured Party and Creditor Package. And along with that you get your initial information via email, and then we send you a box through the mail carrying a ton of educational materials, so that you will know exactly what you do. We have streamlined this thing to limit the amount of reading that you have to do. And we put this stuff on DVD disc so you can actually see this stuff and actually have access to other avenues that may help you with what you're trying to accomplish. Okay? And we also have a second wave of information that we send to you for those who get that package. And this contains more videos, and it also contains the CDs, so that you will be it will be much, much easier for you. This is the easiest way that we know how to get this over to you, instead of having you constantly reading and things. So you can sit down in the privacy of your home. You can put your DVDs in, and you can take notes from this information, and you can learn it. So, in my opinion, that's the most effective way to get this thing done. And of course, you have access to us, and you got questions or whatever. We're going to assist you until you get yourself up and rolling. And once you get this package, we'll pretty much join that to hip throughout life as this thing goes, because we're talking about living in the private. We're talking about living as a free individual. We're talking about doing things 360 degrees away from what most people have been accustomed to doing most of their life, which is living in the public. Okay, so we got a whole brand new ball game. We're talking about protection. We're talking about security for your children. We're talking about putting up a wall of defense against you and your family and your activities and your lifestyle. Okay, this is some of what we are talking about in dealing with this stuff. All right, so now I'm going to get down in here and go back into this common law trust referred to as a UBOT. We're gonna deal directly with the components of what a trust is how a trust is made up. Now it says parties and their roles in the UBOT. How many people at the minimum do I need to create a trust, and what are their roles? We're going to start with the grantor. Now the grantor is the person by whom a grant is made, a transfer of property. The creator of a trust is usually designated as the grantor of the trust. This is the individual that's setting up the trust. If you got a family, you got a husband, you got a wife. Okay, so you're going to structure protection for your family. So whoever it is, if it's the husband or if it's the wife that's setting the trust up, that is the individual that's called the grantor. Now, the next people that we're going to be dealing with is trustees. A person or one of a group of persons appointed to manage the affairs of an individual, institution, business, etc. A person who holds property in trust for another. Okay, so this is the individual that is actually orchestrating the trust. So in order for you to set up a trust and have trustees, the trustees are going to have to be knowledgeable about what you are doing. So you just don't go get somebody because, well, you know, I like Uncle Ned, and I'm gonna put Uncle Ned down here as a trustee. Well, you know doggone well Uncle Ned can't spell trustee. So you want to make sure that the trustees are thoroughly furnished in what it is that you're doing, what you're setting up, what their role is. You want to define their roles in what you're doing. Now, the beneficiaries is the next people. These are the people that you're doing this for. These are the children and all your family members that you have listed as beneficiaries of the trust. Beneficiaries are one who benefits from an act of another, one for whose benefit a trust exists, a person who receives or is named to receive money or property from a trust. And the last one is the exchanger. Whenever you or another party want to transfer any property into the trust organization in exchange for certificates, you take on the role of an exchanger. All right, now let's take a look at the benefits of what are the benefits and drawbacks of a UBOT. The benefits of a UBOT are what? Number one, privacy. Number two, limited liability. Number three, not subject to probate. Number four, no state or inheritance taxes. Number five, minimize and or avoid income taxes. Number six, minimize depreciation. 7, reduce capital gain tax. 8, separate investment program. Now, the drawbacks of a UBOT are when you create a revocable trust, which subject the trust to all of the opposite benefits stated above. Property, number 2, property put into an irrevocable trust is just that, irrevocable, no takebacks. Number 3, the benefits outweigh any drawbacks to establishing a UBOT. Okay, we're talking about a common law trust, and this is very, very important for you to set that up. That gives you, if you're leaving the United States, if you're going to go outside of the United States, you definitely want to have a common law trust set up, and that way there's no problem with you coming back into the United States, because you are what? The people. Okay? All right, now we're going to get back down into some more of this in the definitions and stuff, and the actual construction of this common law trust. But we're going to go over here into one of our little seminars and webinars, so that you can get some more clarity on what we're talking about when we're talking about secured party, the power that you have, because I don't think most of the people that I've been talking to about this, I've spoken to many people across the country about this, and they got the science down. I mean, hey, man, I secured party, and I've done this document, and I've done that, and all this right here, but it to me, based on the people that I'm talking about, I don't think they fully understand the magnitude of the power that you're talking about wielding here. So we want to take a glimpse at it so that you will know what we're talking about. We're going to run this little clip, and when we come back, make sure you got paper and pencil so you can take some notes on this stuff. And we're all going to put it up on YouTube so that you can get this, okay? So y'all hold your hat for a minute, and we'll be right back.
All right. Secured party creditor. If you're going to dabble in enforcement, understanding yourself as a secured party creditor and being able to assert your interest as such. Now, we're going to go over several documents. It's not the documents that make you a secured party creditor. It's not the documents that give you the paramount security interest. However, the process of completing, filing, and executing the documents will serve you in understanding your role as a secured party creditor. So keep in mind that the documents should not be blindly filled out with the thought that, oh, when I fill these out and I send these out and I file these, I'll be a secured party creditor. Rather, look at the documents as your education to understanding your standing as a secured party creditor. I've never had to use one. Absolutely. You're breaching the trust.
That's what 7203 is about.
Yeah, so they create a constructive trust where they're going to now appoint a trustee.
And the IRS and Treasury does the same thing when you fail to file the tax,
Yeah.
return, and pay the tax to settle.
Yeah, what do? They say, well, there must not be a trustee here, so we're going to appoint IRS agent X to file a return for you.
Okay.
And then you get something in the mail going, oh yeah, you filed a return, and this is how much you owe. Really? I don't remember filing that. Oh, well, because that's not you. It's a public trust, and somebody filed on behalf of the public trust. Somebody stepped in and said, I'll be the trustee.
Which is an alleged creditor.
Exactly, an alleged creditor, because it's a constructive trust. They were like, okay, we know there's a trust here, but somebody's not doing something, right?
Fail to perform.
So they literally, every time, this is what, the way I see court is, the judge is there to identify, is there a responsible trustee in the room?
What really screws them up in a tax world is if you do the Form 56, paragraph 4, and resign before they start the criminal aspect or a court collection.
Right.
Because now you're saying, hey, I can't handle it, I'm out of here, you deal with it.
That's what you're doing, is you're now shifting the roles and rebutting the presumption that you don't have a role in the trust. Have you heard about people going into court and going, I'm the beneficiary? Courts crap their pants. In fact, my friend who was telling me about her interview with IRS, it went on for hours. You know what made them get up and leave? When she started talking about a public trust and how she was the grantor and beneficiary. They said, we got to go. Because now, if they're going to lay out a constructive trust, they have to identify her as the beneficiary. She just declared it.
And if she can prove she resigned as a trustee,
She doesn't have to. They're presuming that the trustee's been abandoned. So now that they got the grantor and the beneficiary identified, they have to step in and be the trustee and liquidate for her.
and they got to pay her.
Yeah, they got to pay her.
Yeah.
Yeah, so if you walk into a court case, which is a constructive trust, and you say, hey, I'm the beneficiary of this trust, all of a sudden, any and all proceeds of that case must go to you. They're screwed. They're like, okay, wait a minute. Usually this money goes to our investors that float our statutes, but now because this person's come in and declared themselves as grantor and beneficiary, we have to step in as trustee, liquidate the claim, and pay her.
But the advantage of doing the Form 56 resignation, there's no criminal in on my behalf.
Yeah, that one should be on the mic.
Okay, the reason to file the Form 56, I don't hear anything.
Is it on? Okay.
Try this one.
It's on the audio? Okay. The reason to file the Form 56 and do a resignation as trustee is that when they come in and become the successor trustee, you now have stopped any criminal activity for the failure of the settlement of the trust debts.
Right. But that's now let's take a look at the distinctions of, if I could get my freaking screen to come back, of creditor debtor. Are we acting as the creditor or the debtor? Oh my goodness. My computer overheated. I forgot to plug in my fan. So let me hold on, I need to grab a cable real quick. I forgot my computer goes on complete meltdown. Oh yeah, start at the beginning so we get it
Okay, I'm reading a paragraph. It's on page 10 of this 30-page memorandum that's written by a judge. Under our corporate government's jurisdiction B, no sovereign can lawfully be tried or convicted of any statutory crime. I recently discovered how to avoid prosecution under the trust when a sovereign is taken before a corporate prosecuting attorney or a judge. First, the sovereign must inquire if we are on the record, and if not, insist upon it. Say nothing, sign nothing, and answer no question until you are convinced that the proceedings are being recorded. Secondly, all the sovereign has to say for the record is, I am a beneficiary of the trust, and I am appointing you as my trustee. Thirdly, the sovereign then directs his trustee to do his bidding. As my trustee, I want you to liquidate, offset, and discharge this matter I am accused of and eliminate the record. And fourth, if the sovereign suffers any damage as a result of his arrest, he can direct that the trust compensate him from the proceeds of the court by saying, I wish to be compensated for X many dollars in redemption. This statement is sufficient to remove the authority and jurisdiction from any prosecuting attorney or judge. Now, do you want to comment on that? I think you just said the same thing.
Well, I did, but I was leading into the distinctions between a creditor and a debtor. That is a method, and that is a proven method. That's been done in Canadian courts and American courts, as far as I know, and probably Australian and the UK as well. And that's only because I only speak English. Chances are this type of activity will work anywhere because that's all any corporate court is. It's all constructive trust. That person's basically walking in there in a very uncolorable way and exposing everything that's going on. And because, remember, the presumption is all the roles of the trust have been abandoned when they take control. When you start delegating, saying, no, I'm the beneficiary and you're the trustee, all of a sudden they're like, crap. There is a constructive trust. We're the trustee. He's the beneficiary.
So in a situation like that where, Frederick, you would go into court and say that, and then the judge would say, what are you even talking about? And then the response would be, for the record, are you suggesting that I am not the beneficiary?
You could do that.
Or something.
But maybe just the question, and then say, let the record show when he doesn't respond or when he confesses.
Are you suggesting I'm not the beneficiary?
Right.
Whether and if he doesn't respond.
Does anyone here object to me being the beneficiary of this matter, of this constructive trust? Is there any evidence or testimony rebutting that this is a constructive trust? Let the record show. There is no objection to or rebuttal of the presumption that this is a trust and that I am the beneficiary. And now you just got it on the record.
So even the constructive trust is, you are the beneficiary. You are claiming that you are the beneficiary of not only the private trust, the public, but if they take it to where they want to take over, and it clearly then is a constructive trust, I am the beneficiary of the constructive trust.
Exactly. They have a fiduciary responsibility
and
now.
They are the fiduciary.
Exactly. Yeah. Now keep in mind that this is exactly. I almost see this as a way of stepping out of our role as responsible trustees, because we have the power to settle the debt. Why don't we just settle the debt? If you aren't savvy enough, because I think it almost takes a higher level of understanding to operate as a trustee creditor. as opposed to I'm just the beneficiary. Remember, what was the beneficiary? What interest does he hold? Equitable. So, meaning the proceeds from the court case come to me. Just like when I have, what kind of interest do I have in my vehicle? Equitable or legal? Equitable. So when I sell it, who gets the money? I do. So when they collect proceeds from this court case, who gets the money? I do. What's the name of the trust? Case number 2:10-CV-0852- whatever. That's the trust. It's the name of the trust. Why do you think they give it a unique name? It's an account. It's an account.
Could have the Black's Law definition for constructive trust if you want.
Oh, do you? Yeah. Put it on the mic.
Can you guys hear me at all?
Yeah.
So the definition, it has that, and then it has the quotes after and the quotes are the most important, I think. But the definition is a trust imposed by a court on equitable grounds against one who has obtained property by wrongdoing, thereby preventing the wrongful holder from being unjustly enriched. Such a trust creates no fiduciary relationship. Also termed implied trust, involuntary trust, trust de son tort, trust ex delicto, trust ex maleficio, remedial trust, trust in invitum, and a resulting trust. And then it goes into the quotes, and the quotes are like the best. The constructive trust is the formula through which conscience of equity finds expression. When property has been acquired in such circumstances that the holder of the legal title may not in good conscience retain the beneficial interest, equity converts him into a trustee. It is sometimes said that when there are sufficient grounds for imposing a constructive trust, the court constructs a trust. The expression is, of course, absurd. The word constructive is derived from the verb construe, not from the verb construct. The court construes the circumstances in the sense that it explains or interprets them. It does not construct them.
It construes them by what? Conduct and behavior. You go in there arguing, they got you. As soon as you start arguing, as soon as you do anything but I'm here to settle, or I'm here because I got a claim. I don't know why you guys are here. Well, you guys are here because you're trying to prejudice my interest. And I'm here because I got a counterclaim. Because I gave you the opportunity to prove your claim. You failed to do so. I'm here now with a counterclaim because you're attempting to prejudice my security interest, thereby damaging me. As the paramount security interest holder, I demand you produce a claim. If you cannot produce a claim, then you have none. And if you have none, any action against my collateral and property is a crime, is damaging me, is prejudicing my security interest.
Trespass.
It's trespass.
Yeah, Riverside County lost all its bonding capacity to do with me.
What's that?
Riverside County has no bonding capacity as we speak because of me.
Really?
They trespassed on the property and I nailed them with the commercial process for
$188 billion will get anyone's attention. Who'd you file the claim against?
The two code enforcement officers in the county as the principal.
Nice.
I put my claim into the county and they denied it, said you got 180 days to take it to court. And my attitude is, I don't care about the county. The county itself didn't harm me. It was the two code enforcement officers that come over the fence and started taking pictures and going through my property.
Right. So you listed them. They have bonds. They have public hazard bonds.
But I also went after them privately and their spouse.
Nice, nice. Did you filed various liens, maritime liens, commercial liens?
Yeah, I haven't filed those yet.
Okay.
That's the icing on the cake.
Yeah. Well, see, I tried to do the one with the Coast Guard, and that came flying back. That was a waste of time.
Which one did you do?
The one that Tim Turner was advocating. Says you can't get a file there. So then I looked into the one where he says go to the U.S. Department of Ag. Right now, I'm at a standstill. I'm at a standstill as far as where to file a lien, other than the UCC 1. I did put in there that it was if they fail to respond to the commercial process, that it would be a confession of judgment, and that I told them to seek legal advice for the terms and conditions of the confession, which they failed to do.
I'll give you a little piece of what we were going to discuss tomorrow. We call this enforcement procedures. You have a UCC1 financing statement filed against them?
We have not done that one yet.
When you do.
Well, that's why I'm here, because I want to make sure that last little bit is dead.
And actually, you should do it. I mean, if you've got a claim against the county, you would do it against the county as well. And what you do is you file it with credit reporting agencies. If it's a corporation, such as a county or a state, who do you file it with?
I went to risk management. And I've made a claim against the bonds of the county through risk management, and all of a sudden all checks stopped.
Interesting. See, that's another enforcement procedure. See, I would have waited until I had my UCC ones before I went to risk management, because then I've already got my claim in place and recorded and say, here's a record of my claim. And then really you want to see everyone start dancing in circles? Put it on their credit report.
Well, what I'm
because then they start freaking out.
I'm going to be real nice to the county. I'm 1099-C-ing them.
For $188 billion, I don't know how nice that is.
Then the code enforcement, I'm just going after each one of them for 50 of the $188 billion and 1099-C-ing them too. I'm a nice guy. I'm settling the books. You're compassionate, right?
So when you have a UCC1 filed, you can file that with credit reporting agency.
Yeah.
Okay. Now, is that, as a creditor, all right, trying to stay in a proper mentality as a creditor, is that a card that could be played prior to actually doing that? In other words, okay, well, first of all, when you do that, if you go that route, are you required to notice them that you have notified or filed with credit reporting agencies? Or do you have any obligation that requires you to notify them that you've done that?
I would do it, but you're not required to. Nobody ever
tells me when they report.
Yeah. I mean, in reality, all public records, especially public records that are evidence of a debt or an obligation, belong on credit reports.
Okay, Brandon, what happens if we take the UCC 1 and file it in a miscellaneous filing over at the U.S. District Court instead of Secretary and put a notice with the Secretary and the county? Now
let's hold this over for tomorrow.
Okay.
We want to make it through secured party creditor first.
Can I go back and you say that the trustee of the trust has the paramount security interest in the assets of the public trust. Is that correct?
Yes. The trustee of any trust has the paramount security interest in the property of the trust.
The assets of the trust.
The res.
The res, yeah.
So when you fail to do your trustee duty of settlement and they appoint the successor trustee, now what happens to the interim?
When they appoint a successor